Hello, my name's Ken Vercammen. I'm an attorney in Edison, New Jersey. And, prior to about 10 years ago, most of my practice was criminal and municipal court. And I decided about a decade ago, probably more, goes, hey, listen, let's do stuff that is, in a way less stressful. You can meet nice people all the time. You're not dealing with criminals. And so my program for the New Jersey State Bar Association today is really for attorneys and people working in law offices on how you can make your practice much more efficient and how you can do a better job with your time. And interestingly, so much has changed in the past year and a half, because we used to always insist that everyone write everything down and then come into the office and make an appointment. And let's say, well, what happened back in March of 2020? Well, everything closed. But before that, we started having everyone type up the interview form, email it to our office, and we realized, hey, listen, that makes it easier for our clients, easier for us. People didn't have to take a day off of work. Hopefully some of the suggestions by the panelists today will help everyone. Now, commonly people often ask, attorneys, hey, what, just in passing, you'll see them at public events now that the state's opening. Hey, why do I need to have a will? I'm married. Doesn't everything go to my wife? I goes, well, if everything's in joint names, the same marriage, yeah, but that's not doing planning. That's like driving around without having car insurance, saying, I hope I don't get in an accident. So if someone doesn't have a will, or the will is declared invalid because someone used some cheap form that they didn't sign properly or wasn't prepared properly, number one, you want to explain to everyone the procedure to distribute assets becomes much, much more complicated. So our surrogate's going to address part of this, but let's say there's 3 kids. Well, that means that everyone has to agree upon who's going to be the administrator where there's no will. They have to sign the renunciation in front of a attorney or notary. Renunciation has to be filed. And that's in families where people get along. Sometimes there's someone who says, I'm not going to sign your dumb papers, even though, they don't want, they couldn't be the administrator. Well, that means that a complaint order show cause would have to be filed Superior Court. Everyone be served, spending probably over $3,000, $4,000 in court costs, legal fees. And for most people, you got to explain the having a will prepared for $400, $500 would avoid all this aggravation, all this extra cost. 2, you want to make sure you explain to people that are hemming and hawing. Listen, if you don't have a will, then if it's someone other than the spouse, a surety bond has to be taken out. You're spending maybe $1,000 there per year, and some people have bad credit, can't get bonded. You want to explain, state law determine who gets assets, and more people are saying, listen, I don't want to give equally to my kids. I'd rather have one kid who needs it more than the other. Or sometimes people says, listen, I want it to go to grandkids because they need it for college more than giving it to my son who'll just buy a boat. Good thing to explain is that if you don't have children, close blood relatives, the state of New Jersey and Trenton gets someone's assets, and there's probably nobody who'd say, yeah, I want the people in Trenton to get my money. But most importantly, it's important to explain to people that when you don't have a properly done will, let's say it often causes fights, aggravation, sometimes lawsuits amongst the family. And when people are in mourning, grieving after death, they shouldn't be burdened with one more thing. And for the people that have minor kids, you think about, hey, there's no best person to raise your kids, but who don't you want? And you're talking to clients, hey, who don't you want to get your assets, and who would, your 18, 19, 20-year-olds don't invest money wisely. Now, it's important also to explain people who try to cheap out. Well, what if I just do some online thing? Well, the problem with online is that it's kind of like watching a YouTube video and sometimes trying to do your own electrical work. If you don't do it right, bad things happen. Let's say some people, I'll try to do my own plumbing work. You don't do your right plumbing work, the sewage starts going from the second floor down throughout the house. So you have not saved money. So also you want to explain to the people, make sure that the will is a self-proving will, and it says the word no bond is required. And during the program, we'll try to go over self-proving will. So, logistically, how has my office changed over the past back in January of 2020, it's where we started emailing out the questionnaire rather than having, sending it to people and says fill out in our reception area, because again, people would be sitting in the reception area and then I get the form handwritten. I couldn't read someone's handwriting, and then we do the documents and we spell someone's name wrong. I goes, wait a minute. Let's see, why am I having anyone fill out anything by hand? This way, when if they email you a typed questionnaire, everyone's name is spelled correctly. We've had people's names spelled incorrectly in documents, but that's because our clients themselves spelled people's names wrong. I'd say, we don't charge to make minor revisions, but we do tell people we're going to be charging if Ann Hattie decides I want to change this, and after she signs it I want to change another one. So logistically, it makes the attorney's life easier if the client can look at the form at their convenience at their house. Sometimes they can discuss it with their family, with their kids, but it's they email it back, and then the attorney can call the people. We stopped using FaceTime and things like that because we found our clients didn't want it. They would rather talk to us over the phone, the old-fashioned telephone, and because they felt that when they were, if they had to do this thing by FaceTime, they had to dress up, they had to look real nice, and they just said, I don't want to have to do that. And then logistically, what we do, we started doing more and more where people can pay us online. We do the credit card online. Again, this way people didn't have to send in checks, and the whole idea is making clients happy. So the law office gets a call, and sometimes the first question that people ask is, how much? Well, let's say it's not a good idea to say exactly how much, because you could find out that they have $11 million and wanted a detailed trust. But typically, our office will say the fees range, for a basic will between, 400 and $1,000. This way, we're getting rid of tire kickers that, want something that's going to cost $75. That's not who, you want really to be wasting your time. People call the office, whether could be a will, could be a power of attorney. They have questions. Well, as attorneys, that's what we do. We answer questions. We provide legal advice, but we found it's better if we can email someone a short questionnaire. They can email back what their questions, their concerns are. And if I'm just going to talk to someone for a minute or two with the hands free in my car, we don't charge them. But if the first thing that someone asks is, do you have free consults? Well, I go, then my office says, no, we don't have free consults, because that's usually someone who's just looking for free stuff. So if someone says, do you do free consults? The office, we have script. No, it's, it's a $200 consult fee. People do need encouragement, though. I remember, trying to bring having people come in, because a lot of people are putter offers. And the whole idea is, at least with our probate matters, we said, okay, we can fit you in on Thursday at 11 o'clock. Because most attorneys are going to make more money on a probate matter. We still emailed the questionnaire, but we have, and I'm going to go in the materials. I've included our will questionnaires and forms. Martin Spigner's included forms for the bar. So our will questionnaire. Well, someone's going to type in their name, their spouse's name. And who? It's important to ask also who's it referred by, because we participated in some of the legal plans, like such as MetLife, Hyatt, ARAG, Legalese, and this way, like if they are part of these legal plans, it's their job to obtain claim numbers. It's their job to get authorizations. That's not our job to run around and do that kind of stuff. If it's referred by a prior client, we like to send out some sort of, thank you to that person. I even started calling some of the attorneys that refer cases just to, over the phone, hey, thank you for thinking of us, etc. Even though we're doing much of this online, we still have to be concerned with conflicts of interest, RPC 1.7, because even though we're talking to the family much of the time, it's a family member, you always got to make sure that you're talking to the human being that you're preparing the document, and making sure it's what they want, not what the kid who calls. As attorneys, like Mr. Spigner, Ms. Quattrone, their offices, they're also getting calls. I need to get power of attorney over mom, dad, or Uncle Joe. And listen, we want to help out people that are like ill, etc. But the question got to be, okay, can mom, dad, or Uncle Joe come into the office, or are they able to talk over the phone and specifically say what they want? If the answer is no, they can't talk over the phone, then when we stop and goes, well, then we can't do it. You might have to go through the guardianship process. That's okay. Executors. Let's say your interview form, you should make it easy. Have the person type in who's going to be executor 1, who's going to be executor 2. Let's say, and why is that important? Well, let's say explain why joint executors is a bad move. You could have twins living together, but that means that 2 people have to sign the paperwork for the surrogate's office. 2 people then got to sign a listing to sell the house. 2 people got to go and open up the bank account. 2 people got to go to the bank. 2 people got to sign the contract for sale. 2 people have to sign every check and do everything. 2 people have to go to the closing. So why make twice as much work? And those are for people who get along. Sometimes you get family members that can't hate each other, can't agree upon anything. We handled a probate matter in Ocean County. There's 2 brothers, and the one brother would say the sky is blue. The other one says, no, the sky is gray. You're stupid. You've always been stupid. And I remember the judge, the probate judge, finally saying, fellas, why don't you guys go and get a cup of coffee? There must have been some good times when you were younger. Think about the good times that you had, not the bad times. Currently, New Jersey did away with the estate tax 2 years ago. There is talk by the Democrats in Trenton about bringing it back. The same thing federal-wise. The estate tax starts at $11.7 million. People in Washington want to lower it and start taxing. But at least right now, that's why, at least for my people in Central Jersey, most of them don't have, $4 or $5 million. So it's important to at least get a little bit of information. You don't need account numbers, but okay, where do you have real estate? Ask them. I'd say, how about other, what New Jersey? What about other states? Because explain that if you have a real estate in other states, you still have to go through ancillary probate. So, in other states, it may be a better idea to set up a trust. My mother-in-law used to call me every other year and say, I want to come in and get a trust done. And I would say, were you watching Susie Orman on TV? And she would say, oh, yes, I was. I goes, hey, Susie Orman is exactly right. If you live in Florida, New York, California, where the probate process is very expensive, very complicated. But in New Jersey, for most of the states, you're paying about $150 to the surrogate. They need the original will, original death certificate, the form filled out, check. They send you the papers, and basically, there's not that much more that the surrogate has to get involved in. So that's why we don't ask people about, the account numbers in estate planning matters, eventually, probate matters. Obviously, we need that kind of stuff. Now, before I go further, let's see. Very important that you go over with the clients that you could do the best will for them on the planet, but certain assets don't pass by way of will. Certain assets pass directly to a beneficiary. So certain assets pass by title. And think of a house owned husband and wife, tenants by the entirety. That automatically goes to the surviving spouse. Let's say if there's bank accounts and they're POD, joint tenancy payable upon death, if they're by title going to someone, the will can't change that. And people don't understand that. They think that if they do the will, that changes that. So part of what you got to do as an attorney is kind of, you're protecting them, you're protecting the beneficiary, but you're protecting yourself. So we put that in our interview form we send out. Then when we email out the will, we put that in the documents. And then when we email our thank you letter at the end, it's in there a third time. So again, no one can say, oh, and no one told us that. We never heard that before. A will cannot, in certain assets, pass by way of contract. Think of IRA, 401k, life insurance, annuities that have beneficiaries. Explain to the clients, a will cannot change who's getting life insurance. And it's also, we recommend people that it's a good idea for them to get a printout of who their beneficiaries are and put it in their will file, and also not put the will in the safe deposit box. Well, I'll try to get into that later on during the program. Okay, so as the attorney, you've like the client has filled out the form, and then your questionnaire typically asks, okay, who do you want to get your stuff? Who's the beneficiary? Now, when they're married people, sometimes the form will come in, as a beneficiary, the 3 kids. So then you got to call up and say, okay, do you want to disown your spouse? Yes or no? No, I want everything to my spouse. Okay, well, your form says, everything's going to your kids. Oh no, I want to. So don't just assume that what people type in is what they want. More and more, we see people not following what was the traditional American plan, where everything was going to spouse and to kids and to then the grandkids. And last year, a nice lady was talking to me and said, "Do I have to treat all my children equally?" I goes, "No, it's whatever you want. Whatever." She goes, "Well, one of my sons we don't hear from much. He lives on the West Coast." Well, let me ask you a question. Did he get a card or a call on Mother's Day? She goes, "No." Did you get a card or a call on your birthday? No. Did he get a card or a call on Christmas? No. Well, why should you leave this guy anything? Because this guy is going to be the biggest problem, because when you pass away, that person's going to get an equal amount. And that's another reason why people should have wills, because it's kind of sad where you have the one kid that was the one that really took care of mom or dad. Not because they want to get a windfall, but because they were concerned about their health and their safety, making sure their medicines were there, making sure there was food, making sure the driveway was taken care of. But if the mom or dad didn't have a will, the person that their last letter to mom or dad said, like, don't ever contact me again, well, that person gets an equal share. So again, it's it's nice to have it in writing. Some of the older clients are not as good at email. No problem. We can still have the family members type everything up, but we got to go over with them over the phone. And when you're doing your wills, there should always be a what if that person dies. Don't leave anything dangling. Now, some people also want and have specific bequests. They want to leave a certain amount to certain, we leave $10,000 to this grandchild, that grandchild. They want to leave $10,000 to, the American Cancer Society. Well, if it's to a charity, try to be specific. There was like litigation where monies were left to a charity, but it was unclear, because different different charities have different. I'm handling a probate matter where the beneficiary of the trust in the end is United Cerebral Palsy. Well, there really is no such entity anymore. There's a national United Cerebral Palsy, but the fellow put in United Cerebral Palsy in Middlesex County. Well, you go do a Google search, that does not exist. Some people want their jewelry to go to a daughter or granddaughter. So tell them, listen, when it's stuff dealing with value, so there's no fighting. It should be in the four corners of the document. On Mother's Day, Mom could have said, listen, I want to, and everyone has a camera and everyone's filming everything, and Mom could have said, hey, listen, and someone else, the kids are all filming what, Mom or Grandma has to say. I want my jewelry to go to, my grandkids. Well, not only does the executor not have to follow that, the executor isn't allowed to follow it unless it's in the four corners of the will or unless everyone agrees in writing. And the clients will say, "Oh, my kids won't agree, or my daughter will do the right thing." And he goes, "Listen, I'm sure your daughter do the right thing while you're alive. She's not going to say to you, listen, and when you pass, I'm going to screw like my brothers and sisters." But a lot of times, the executor is influenced by whoever their spouse is, whoever they're with, because their spouse might say, "Hey, listen, I spoke to a lawyer, and the lawyer said." That account where it was you and Mom were listed, that's our money now. Well, let's see, that doesn't have to be shared with everyone else. Some of the men that are sportsmen say, listen, I want my firearms to go to another family member that has firearms, or because we find out when a guy is the executor, he'll look at this jewelry and he'll go bring it to Cash for Gold. And he goes, hey, what do you give me for this junk? Some things have some sentimental value. I had a client that he only had one child. That's everything would have went to the child, if he passed without a will. But he had this antique musket that was passed around from generation to generation of family members from the French and Indian War. And it was so important that he do a will that says, if I pass away, this musket goes to, it was kind of like the next male in line in the family. This old rusty, dirty looking thing that could never be filed again. But that's what that was important to the guy, and that's why it's important in your questions. You have that line. Any specific bequests of money or property. Now, I think I've been in practice over 35 years, and one of the second or third wills I ever did in my life. I was working for a law office in the Red Bank area, Dresden and Warsaw, and a lady, I asked that question, do you have any specific bequests? And the lady had, 11 pages of papers, single-spaced, double-sided. Everything the lady had in the house was listed. She would take the bottom of the stapler written down who goes to this. So sometimes they say to people, listen, if you want to do that, it's going to cost you more money unless it's written down. But there should be a clause that says if it's a specific item, if this asset is no longer in the house, then the bequest shall lapse. Because sometimes people give away something ahead of time, or it can't be found, and the executor shouldn't be forced to fight litigation where someone was bequested Aunt Mabel's wedding ring and it can't be found in the house. Now also some people have what we call the reverse specific bequest, and that is I leave nothing to X person. We don't leave them a dollar. We don't put a reason. Don't give them any grudges. I make no bequest to X person and their children. Let's see. That way, it's clear. They still need to be, if the person passes away, they still need to be served with a notice of probate, and the notice of probate indicating that a copy of the will be provided upon request. But this way, now, who gets stuff? So. Sometimes you may recommend to the client, listen, let's say it's a second marriage situation. The people are or saying, okay, everything's going to go to my new spouse, and after that I get split 50-50 amongst the family. He goes, you got to tell them, that is the worst thing possible. And they go, why? I goes, well, because after you pass, your spouse can have a new will done that says your kids get nothing, or it goes to their new spouse. And they both look at me. It's kind of like, I remember Tom Begley using sometimes the word like, scaring people, ice pick in the eye. He goes, well, yes, let's see. Third marriage, well, there wouldn't be no third marriages. Well, you weren't planning a second marriage, and you're both here now. My job as the attorney is to kind of protect you. So you could set up, instead of the money going outright to the spouse, set up a, within the will, a testamentary trust for the spouse, and that way, New Jersey doesn't have an estate tax now, but they do have it one in the future. Prior to New Jersey, when it was $675,000, we were doing these spousal trusts all the time to try to, save people estate taxes. Also, sometimes you got to ask in your questionnaire, are there any kids receiving SSI, SDD, or any kind of governmental assistance? Because they could, if they're getting a big lump of money, they could be declared ineligible for those types of benefits. So sometimes you'll set up a testamentary trust for those people, and it's important that they comply with the provisions under New Jersey's Trust Act, because we did enact the uniform portions of the Uniform Trust Act. But I helped a family where one of the kids was an alcoholic, and mom was smart enough to set up a testamentary trust for the son, where one of the kids was the person that was the trustee and made sure that the guy's, the guy worked, part-time, but he was an alcoholic, and from job to job, he was in his 50s. But this way, rent could be paid by the trust. His car insurance could be paid by the trust. Other expenses could be paid for by the trust. And then the trust would buy the fellow like a ShopRite gift card so he could buy food. And that was important, rather than having the person have, access to, money, because you give an alcoholic $100, they buy $100 worth of booze. You give them $1,000, they buy $100 worth of booze, and they give away the other $900. So part of your job as attorneys is, looking past sometimes what people want. Over the past year, people have been calling my office in Edison. I want to come in and sit down. I goes, you don't need to sit down. Just fill out the question. Well, I like to sit down. And sometimes I'll smile on the phone. He goes, okay, Mr. Shah, are you looking to disown your wife? No. Are you looking to disown any of your kids? No. How old is your youngest kid? Let's say my youngest is 9 years old. Mr. Shah, I know what you need more than you know what you need. Because, again, this is what I do for a living, and I goes, listen, let's say, I'm not, I told the clients, I'm not trying to brag, but again, our job in helping people is kind of knowing what people need in the future. Okay. And so, when I need a knee surgery, I didn't need to ask a lot of questions of the doctor doing the knee surgery, because let's say I was able to ask the doctor, hey, you've done this before? Yes. Okay, do the best job you can. Let's see. So it's important that, if, you want to make sure that if there's young kids, they're not getting money. Typically, in our wills where there's minor kids, it goes to spouse, and then they get some when they're 22, some when they're 25, the balance when they're 30. But as much money as could be used for college education, support, etc., can be used. My son graduated dental school, and just the tuition alone was $115,000 a year. On the other hand, you explain to the clients, I'd say the kid says, college is very stressful. I need to take time off. I want to take a trip across the country with a whole bunch of my buddies, and I need, $50,000, or I want to go on a cruise with my girlfriend and 15 of my friends, and I need $60,000. The trustee can say, no, your parents didn't work hard, so you could goof off. All right, so as attorneys, it's important also to explain What's the job of the trustee in the will? Well, Martin Spigner is going to discuss, different types of trust, but a trust within the will. Hey, the trustee holds the money, the guardian holds the kids. So, again, sometimes people are put off, or sometimes, well, I can't decide. I goes, okay, if you couldn't come home, Mr. Klein, for the next 2 weeks, who would you trust to watch your kids? Well, I guess, my mom. My mom's watching my kids now. Okay, good. She's number one. Well, she's getting older. Yeah, she's getting older, but the idea is the document we do now, let's say, it's good now, and it's good. It could be good. You could always make changes in the future, but the idea is no one's planning on something happening right away. But hey, things happen. I'd say we were busy last March and April because hey, people were like with COVID, people were concerned that they were going to breathe on someone, even wearing a mask, when they went to ShopRite to buy bread, and that they were going to die the next week. So, sometimes when people can't decide on the guardians, okay, who don't you want? And a couple of times we said, okay, who's left in your family? We wrote the people's names down on pieces of paper, and we spun them around, and we just picked pieces of paper. Make sure that you do wills that are self-proving wills. I'm helping out the law in a law office where the attorney became a full-time judge. So, but I said most of their wills were not self-proving, and it's sometimes difficult for the clients to try to locate the witnesses, and it's not really fair to the clients. If you should be doing self-proving wills now. The law changed there, decades ago. And so explain to the clients, what's the value of the attorney? Well, the attorney will do a self-proving will to make it easier so the executors don't have to go and find witnesses. And also the attorney will help the estate by doing a no bond required. So again, we're trying to make things better for the clients. Let's see. I mentioned different types of trusts within the wills. So again, you talk to the people, and the other positive of trust within wills is that if you have a spousal trust within the will, hey, that's protected, from Medicaid, it's protected from taxes, protected from creditors, and it's protected from if they do decide to get married a third time. Well, that if that third spouse has to go into a nursing home and they run out of money under federal law, you're responsible for your spouse. Let's say, doesn't matter if you're separated for 10 years. And people says, well, we have a prenuptial agreement. Good. That's fine between you and the divorce court. That's fine between you and, let's say, the other person's family members. But the federal government says, we don't care about your fancy prenuptial agreement. If one spouse has to go to the nursing home and they run out of money, the community spouse got to pay. And Ms. Quattrone's going to touch more upon that, but it's more trying to head it off when you're sitting down talking to people, make sure that if you can't do it right, don't do it at all. Sometimes the family members, well, this is what mom or dad wants. Okay, good. I need to talk to them, be 100% satisfied. We used to, in the materials as a form when people couldn't come into our office and sign because of illnesses, disability, where a doctor's signing a certification saying, yes, they're competent to do a will, a power of attorney, a living will, a trust, a new deed, etc. But it's more than just getting the doctor to sign that. It's, discussing with the client what's in there, what do they really want. So a quick story that I share is Johnny calls up and goes, my mom wants to put the house into my name. Okay, good. When can mom come in? Well, mom can't get around much. She has health problems. Okay, I need a note from a doctor saying she's okay mentally to do whatever, and I need to talk to her. So, okay, fine. They get the note from the doctor, and they put her on the phone, and he goes, hey, Mrs. B, how you doing? She goes, well, I'd be better if I wasn't on an oxygen tank. Okay, Mrs. B, what do you want to do? I want to sign the house over to Johnny. Well, 80% of the attorneys would say, okay, that's cool. I just made $800 real fast. But you got to follow up and ask the next obvious question. I'd say, Mrs. B, how many kids you got? I got 3. Well, Mrs. B, do you understand that if you sign the house over to Johnny, that becomes Johnny's house. And I'd say that means the other kids are really getting nothing because the house is the only thing you really got. Is that what you want? She goes, oh, no. I want all my kids treated equally. That's what I thought. Put Johnny back on the phone. So that's one of the rare instances where possibly putting the house into a irrevocable Medicaid trust would be best. But some people want to cheap out and just say, well, okay, I just want to put the properties into all my kids, my 3 kids' names, 2 kids' names. So it goes, okay, well, do you understand? Make sure you explain to them, if you do that, it's not your property anymore, and they can kick you out. Well, okay, I want then a life estate within it. Okay, fine. Well, I was involved with litigation in one of the counties where, the old man, didn't want to spend the money on a trust. He just decided, okay, I'm going to put half the house in my son's name, half the house in my daughter's name, and then transfer half of my assets to my 2 kids, hoping that, and then, if 60 months go by, I'm eligible for Medicaid, good. Okay, I saved all the money on that trust. Well, what happens that no one predicted? The son dies suddenly. Well, okay, now who owns half of everything that the old man owns? His ex-daughter-in-law. So the family sends a letter to the ex-daughter-in-law. Hey, listen, can you do us a favor? Sign a new deed transferring the house back to him and transfer all the assets that he had given to your late husband. And I represented the lady. She goes, what do I have to do? He goes, tell him you don't have to do anything. That's your money now. That was your husband's money. It was a bonus. It was a gift. It was a full gift that transfer was made. It's more than just saying, okay, good, I want to rush through these things. You'll get, as attorneys, you get calls, oh, I need to get power of attorney over Mom, Dad, or Uncle Joe. Let's see, you got to explain to them. You can't get power of attorney over anyone. They have to affirmatively contact the attorney and say, I want to give my power of attorney to someone. Because these are the common calls you'll get on a Friday around 4 o'clock saying, we need to get power of attorney over Mom today. We need to get a living will done for Mom today. In me nowadays, I don't want to rush anything. If it doesn't smell good in the beginning, it doesn't smell good later on. Okay, so as the attorney, say the client's emailed you their information. Say you set up and it's in materials a will bill or how to pay by credit card. Let's see, you got to do that because first of all, RPC 1.5b says any fee has to be in writing. Let's see, if you do a $200 power of attorney for someone, still got to be something in writing. Let's say, so you wanted, I have in the book for the state bar, I put some materials, but also we put in big letters. The law office does not open up a file until the law office is paid in full. They goes, what's your payment plans? There is no payment plans. You put in your credit card. You pay them off down the road. Hey, some people will say, oh, I want to think about it. Okay, it's like, I want to think about whether or not I want to have health insurance, life insurance. Listen, get it done. Sometimes it's a call to action. I'd say some people would say, well, I'd like to read up on this. And I've said to people, you don't need to read anything. I'd say, you come to an attorney that is went to law school, passed the bar, has attended seminars, has read books. I told one guy, listen, I'd say, I wrote a book on this stuff. And helped write the New Jersey bars, handbook, nuts and bolts of elder law every year. You don't need to read anything. Just like I said, I'd say, I didn't read anything about knee surgery. He goes, doctor, do a good job. Well, Mr. K kept on saying, "Oh, I want to read up. I want to read up." Let's see. He also didn't want to pay after 2 consults. Well, you haven't done anything yet. And we're doing tax planning. This. He goes, fine. I say, okay, Mr. K, listen. I'm not doing anything further. You can hold on to that, but until, we're not going to do anything until you pay us, because we've already had 2 consults. We went over, some tax planning. And about 2 years later, my office gets a call. It was Mr. K's daughter. He goes, "Oh, Mr. K died. We found some communications from you. Do you have his original will?" I goes, "No." Mr. K kept on saying he wanted to read up, and he never did his documents. And the family had to pay tens of thousands of dollars in New Jersey estate taxes because he wanted to think about it. So, you got, again, you put a call to action to people. Now, logistically, we used to put all the documents in the mail to people, and then with COVID and working remote, I wasn't in my office for 7 weeks in the building. There was cobwebs by the front door. We emailed it to everyone, but I put in the email, okay, attached is your will, power of attorney, living will. Please print out. That was the second line. I said, don't be reading this document on your iPhone. Don't read it on your iPad because you're not going to read it. Print it out, because then we gave instructions on how people can sign at the UPS store. Because when the state of New Jersey closed, the UPS stores was one of the few entities that was open to the public. It was open for business. People could go there, and we gave it. We have instructions on signing with 2 witnesses. Now, we do say to make people's lives easier, if it's the first marriage, the spouse can be the witness, but someone else has to be another witness, and the spouse should not be the witness on the power of attorney. None of the agent 1, agent 2 should not be the witness on the power of attorney. It should be a different person. Let's see. So again, protect. It's a good idea. Now, let's see. Why do we want see the stuff ahead of time? Well, when I was a young attorney, I remember a fellow calls. "Oh, Dad wants to have a new will. Wants to have a will done and wants to sign a house over to me." And but he has a bad leg, and you're anxious for business when you're starting out or you're switching careers and you want to learn. So I remember going to the house, and the son didn't live with Dad, but the son goes, "Oh, Dad's inside," and the dad's watching TV, and the son goes, "Okay, Dad, this is an attorney, and he's going to explain to you why you should sign the house over to me." And the old man looks up and he goes, "Who is this?" He goes, "It's an attorney." And he has to speak louder. "It's an attorney, and he's going to explain why you should sign a house over me." And the old man goes, "Who? What?" He goes, "I'm not signing a house over you. You'll sell it and kick me out." That's when I realized that the son never even told the old man he's trying to pull a fast one. So I'd say beware of undue influence issues. Beware of the confidential relationship. You don't want to be the defendant attorney in a case like In Ray Stockdale. We again.
And is this a good time to interject for the CLE code? Yeah. Sorry. Yeah. So the 545 code is 36821. 36821, and I'll put it in the chat also. Thank you.
Excellent. I like that. I like that chat. I like that chat thing. That makes life easier. Okay, so Martin's going to talk about the revocable trust thing. But when people come in, "Oh, I want to do a deed," they think it's like a car title where you just sign the back and it's done. He goes, "No, not only do you need to have a whole new deed done, but you need the seller's residency certification, affidavit of consideration, a check for about $150, the county clerk cover sheet, and mailing letter to the clerk." So it's more than just it's additional work. I'm still old school though. When the people, if someone really has to come into my office, I mean, I got the germ guards, and I got both of my vaccines done. I still wear the mask, but I like to give out paper to people so they can read, but not that much. Okay, now on the day if people are signing in our office, in addition to the typical like germ stuff with masks and telling them to bring their own pens. Like we were signing in the parking lot of the office until last summer when it was 85 degrees out and sweaty. We were having people come in and sit 7 feet away from me. You ask the simple questions. Hey, did you read it? Does it contain what you want? You have ID to prove who you are. That's important if they're signing in your office, because if someone says, no, I didn't read it, then the word is stop. I'd say I'm not going to be a witness to something where someone says, no, I didn't read it. I don't want to be on the hook. And again, sometimes someone says, if someone says I looked at it, etc. But I do remember a time where Mom was not in good health. Mom was kind of older, and Mom says, the question's asked, say, did you read it? And Mom says to my staff, no. Well, then we're rescheduling this for another day because we got to make sure that, this daughter that brought Mom in, and then, 3 or 4 minutes later, the daughter goes, oh, she misunderstood. She did read it. Goes, no. We know what we heard. And, I'm not going to do anything to jeopardize my license. And where someone says, no, I didn't read the document to my staff. Interesting with will signings, let's say I used to love going to Tom Begley programs, and Tom Begley would talk about, hey, he goes, let's see, for the signing that can be delegated to staff, and he goes, because as the attorney, there's only 2 things that only the attorney can do: give legal advice and go to court. But everything else, the staff can do. So, my office can still operate when I'm not there. People can come in, sign in front of one of the notaries in our office to make life easier. Okay, let's now talk about the power of attorney. Let's say, so I mentioned with the wills, you're talking to clients that they're trying to cheap out. Goes, well, your cheap thing probably is not a self-proving will. It's probably doesn't have no bond required. With the power of attorney, you want to make sure that there's clauses that talk about being able to sell, transfer real estate. You want to make sure that there's clause, and there's in the book there's clauses, but kind of a good thing to explain to people is that, listen, a lot of banks used to give people a hard time saying it wasn't done on their form and had to be redone on their form. So New Jersey legislature, created in the power of attorney statute that says, hey, the banks, financial institutions, financial planners had to honor the power of attorney if they did business in New Jersey, but as long as it referenced the New Jersey statute. And I'm pretty sure those free cheap things that people find don't reference Section 2 of PL 1991, C95, C46:2B-11. And periodically, client will say, oh, the bank says the power of attorney isn't any good. He goes, what, the power of attorney did last year? No, it has to be on their form. And I say, BS, listen, let's say, here's what we're going to do. Let's say, or you're going to do. Okay, you go talk to that bank teller supervisor and say, listen, it's a valid power of attorney. If you're not going to accept this, I'm filing a free complaint tomorrow with the Department of Banking in Trenton, saying the bank is violating that New Jersey statute. And in addition, I'm including your name in, the person at the bank that says it has to be done on their form, because you're in violation of the law too by telling wrong things to people. A lot of these tellers and, bank staff, they're just doing a check-off box. But where people sometimes, your clients will say, I don't need a power of attorney, I'm not sick or old. I goes, hey, we do powers of attorney for 18-year-olds when they're going off to college. We do powers of attorney for sometimes people that are getting married, where mom says, listen, I know you're getting married, but I think it's still a good idea to have me as your contact person rather than your spouse. But the whole idea is, let's say, the cost of a power of attorney is a couple $100. The cost for a guardianship where someone doesn't have the power of attorney, you're looking at spending thousands of dollars, having to go through the guardian, having to file, get 2 different doctors to sign a certification or affidavit, filing the complaint in the Superior Court, having the judge having prepare an order show cause, having the court set a date, having the independent attorney appointed, having to go through all of this. So he goes, you're spending $3-4 grand, and say if it's not done, someone typically got to shell out the money to hire the attorney ahead of time. He goes, we don't do anything on contingency. When someone says you can get paid at the end, the answer is no. That's not how I work. You're going to put it on your credit card, or you're going to pay us. So the power of attorney, it's effective either right away or only upon disability. If it's effective right away, durable power of attorney, it's effective right away and stays effective if someone becomes disabled. Springing power of attorney only springs into effect if someone becomes disabled or otherwise incapacitated and there's a note from a doctor, and it's pursuant to the New Jersey statutory definition of disability, which is set forth at 46:2B-8 to 8B. And sometimes you get people, it becomes difficult where it's only upon disability because you get someone that is an alcoholic or they're addicted to drugs. And they're not going to go, you can't get the note from the doctor because they won't go there, but they really do need the help. So I encourage people, I say, listen, make it effective right away and not upon disability. One of my interesting clients who I liked, he goes, Kenny, listen, I'd say, he goes, I'm a carpenter, you're using legal terms on me, durable and springing and 2B this and 3B that. He goes, explain to me in carpenter terms. He goes, okay. If it's effective right away, your son, who's going to be your agent, can steal all your money right away. If it's effective only upon disability, your son has to get a certification from a doctor, a note from a doctor, before he steals your money. Knowing that, you trust your son. The guy goes, I trust my son with my life. Okay, fine. Then make it effective right away. Don't make it effective only upon disability. It is also important to explain to the clients that, listen, only the original will can be admitted to probate. And people goes, what's a probate? And I goes, think of the surrogate as, in Pennsylvania, they call it the Register of Wills. Let's say, kind of sometimes I'll try to make it easier. A fancy name for the will clerk. The original will, original death certificate, check for $150 a form, and it's in. However, they cannot admit to probate a photocopy. They can't admit a scanned copy, and if the original can't be found, then it's presumed that the person destroyed it. So, we typically tell the clients, listen, go to Costco, buy a fireproof box, put it under the bed in the attic. The basement isn't as good because if there's a flood, it's gone. But don't put it where you keep your jewelry. It doesn't need, and never put it in a safe deposit box because don't assume that the executor can get to it. And it's it should be in a place where someone can get to it on an emergent basis. Sometimes a power of attorney is needed on an emergent basis. Sometimes a living will is needed on an emergent basis. Someone's in a hospital. That bank is not going to open up on Friday night or Sunday afternoon because you need to suddenly get the living will. Now, we do recommend people, after you've signed the power of attorney, it is a good idea to scan the power of attorney, email it to yourselves, email it to Agent 1, Agent 2. If you want to send it to other family members, that's okay. But also scan it and send it to the financial planner, the accountant, if you have a banker, anyone, life insurance person who's ever dealing with your finances. That way, they already have it on their in their database so that you can call them, and it's not the first time they've dealt with you. With the living will, it's a good idea to scan it, email it to each, to yourself, to different family members, and to doctors, and that way, it's. And we've told people, listen, it's on your. You can conceivably get it on your phone because if it's emailed to you, it's on your phone. You can go to your Hotmail account, or I use the good Apple version. But I remember a hospital asked me one time, do you have a power of attorney for a copy of it? Yes, it's on my phone for X family member. Okay, let me now. And sometimes people will want life estates and property. If they transfer, okay, we can do that. Clients under disability, you have to make sure it's what they want. There's also under the Christie administration, they signed what's called the Digital Fiduciary Act. But sometimes it's a good idea for people to do a letter of instruction and indicate, hey, where's your passwords for your stuff? There's a new thing called Bitcoin. If someone had $100,000 worth of Bitcoin, but the password can't be located, you can't call up the Bitcoin company and say, hey, I'm the executor. I need to get into that. Okay. Let's talk now about the Living Will Advance Directive. The living will is a document where you explain to the clients, let's say, hey, you're giving instructions to hospitals, doctors, etc., that in the event someone had to, is in a coma, irreversible condition, there's no hope for them, they can no longer talk for themselves. You're giving instructions to hospitals and doctors, hey, what would you want? And kind of the power of the living will is not really for you as the the person signing. It's for your family, so your family is spared the trauma of fighting over what to do. I'd say, and I remember once years ago where I had the doctor says to me, okay, it's for someone who did not have a living will, and the doctor's saying to me, okay, should today be the day? For someone that they're not going to be coming out anymore. And what the right decision is for someone who's 92 years old that's never going to open their eyes again and never going to converse or do anything. But you hate to be the one to say, okay, yeah, let's end that person's life today. I couldn't even do it for my dog, so explain to your clients, listen, people sometimes shy away from doing the living wills. Oh, it's not permitted by my religion, or no, it is permitted by religions. It's something important to have. So with the living will, you're defer, and we took some language from the medical society. So with the living will, you're indicating, okay, someone's in a coma, irreversible condition. Who's going to be, let's talk about fluids and nutrition. Fluids and nutrition to be provided, or fluids and nutrition to be withheld. And I'd say, it used to, nowadays, probably about 85% of the people say, listen, if there's no hope for me, I don't want to be on feeding tubes, etc. I'd say, and some people says, well, I think my religion bars that. He goes, no. Talk to your priest, talk to your rabbi. There's not a prohibition on this if the doctors have made that kind of call. Someone's brain dead. They're only being kept alive through a respirator, etc. Now, the next section we usually have is directive as to medical treatment. And 99% in artificial machines, and 99% of people now, at least in my office, say, listen, if there's no hope for me, I don't want to be kept alive for long periods of time where my family has to suffer watching me there, and then they get hit with the deductible at the end. We added in our powers of attorney. We added a HIPAA clause in our power of attorney a couple of years ago, and then under the New Jersey Caregivers Act, we added. We also added the HIPAA clause to the living will, and we added under the New Jersey Caregivers Act designation under both our powers of attorney and living will, so that you're picking you're typically oftentimes it's the same person as your executor, but it can be a different person. So sometimes you might your clients may have a child that's good at money, but they don't think that they would be strong enough to be the person on the living will to make make some decisions. Okay, some people want someone who has more knowledge in the medical field. Hey, fine. But the reason why you want to explain to clients how important it is for the living will is that without it, let's see, number one, HIPAA law doesn't prevent doctors really to provide stuff, and it prevents the fight in the hospital room. and it prevents the person that wasn't involved with helping out, wasn't involved with mom or dad's whatever, like, medical care, and all of a sudden the kid, like, comes in from Western New York that visited once or twice a year, walks into the hospital room and says, okay, I'm in charge now, and this is what we're going to do. So the answer, you want to be able to have the clients have a living will to say, no, you're not the person who's decided. They've already picked this, this person, that person, and the hospital has a copy of that. It's a good idea to add in your living will clauses organ donation yes or organ donation no. And I've been encouraging everyone, no matter what their health, what their age, to sign the organ donor card, because again, it's trying to like help other people in New Jersey. And I went to an interesting program put on by the NJ Sharing Network, a full day seminar, and they're the ones that handle organ donors. And I said, by the way, I asked the question, what's the maximum age to be an organ donor? And they said there is no maximum age. I goes, well, what's good on an 85-year-old guy? And they said skin and cornea. I goes, wow, I never thought about that. If I was burned in a fire, I'd rather have old guy skin than the stuff got burned off me. If I couldn't see, I'd rather have old guy. I also asked the question, and this was like 4 years ago. He goes, what diseases disqualify someone from being an organ donor? Because to be a blood donor, the disqualification list is 8 pages long. They goes, at the time, the only disqualifier was being HIV positive. Well, interestingly, the New Jersey statute has changed. That is no longer a disqualifier. Someone with who's HIV positive can be an organ donor. They can donate, to someone else that's HIV positive. So, one of my like, clients, his like, he's HIV positive. His husband's HIV positive. If one of them needs a kidney, hey, listen. Someone, a lot of people would say, listen, I'd rather like, donate one of my kidneys than have my spouse die. That's an easy call. The doctor said to me, listen, let's say your spouse is gonna die unless they got a kidney. You're the only match. Okay, I guess I'm gonna miss a couple of running races, but again, it's about doing the right thing. It's make sure now. The living will document is a good document. The people scan it. Often afterwards, we do a post will letter with additional instructions, and I mentioned about scanning things, but also recommending people prepare a letter of instruction and somehow have a list of assets, because if the kids don't live with them, they're not living together, you're making it easier for them. And more and more passwords and what your accounts are. The old days, if grandpa passed away, all you need to do is do a change of address form and you'd be getting their statements in the mail. Well, people do, more and more of their things electronically. And Martin might touch upon that during his presentation, but so it's very difficult sometimes to say, when everything was done electronically and the executor can't even log into, open up their iMac, their Mac computer, because they don't have any passwords and they can't get into the email, etc. So part of it again, a call to action. If let's say if you're not sure of what all the assets are, well, again, you can look at the prior year's income tax return, and where there's dividends listed and like interest, etc. At least that gives you a starting point. But the surrogate's going to deal with some more of the probate asset aspects, and Martin and I can touch upon that. Okay, so I've covered a little bit about the preparation of documents, and my name is Ken Vercammen, and I'm an attorney in Edison, New Jersey.